Lawyers of Reddit. What is the most unethical thing you have seen someone do for a lawsuit and won? Story 1. Attorney flips doctor's report to win workers' compensation case. For a year, I worked for the most unethical attorney I have ever met. Here are my top 2 stories. He took on a client that was injured at work. He sent him to a doctor that he would refer to as a quote. Since the attorney normally does defense work, the doctor came back saying the injury was clearly not work-related. The attorney called the doctor to inform him that he represented the employee and not the employer in this case. The doctor then wrote a report that the injury was clearly work-related. Story 2. Advising client to transfer contaminated site to assetless limited liability company. I started out working for a commercial law firm advising companies on environmental compliance. We had a client who was a large oil and gas distributor, which owned a contaminated site in a populated area. My boss advised the client to transfer ownership of the site to a newly incorporated limited liability company with no assets. That way, when the government ordered the site to be remediated, the client wouldn't be liable for the cleanup. I left not too long after that. Edit. I'm not based in the United States. Yes, lawyers exist in other countries too. Story 3. He told OJ to struggle when putting on the glove. Story 4. Corrupt lawyer wins case through friendship with judge. Obligatory, not a lawyer, but my parents got caught up in a slimy lawyer's talons. Basically, they had carpet installed in their house in 2005, paid in cash, got a receipt, and went on with their lives. 7 years later, they get a letter from some law firm saying the company they'd had install their carpet never received payment and would press charges if they didn't pay up. My dad, being the paranoid jerk he is, had kept the receipt and said he'd see them in court. He did some research, found out what the attorney can and can't do in this situation, and also found out that the attorney had been working with the flooring company for years, accusing paying customers of not paying and collecting excess money from them under threat of lawsuit. Fast forward to the court date. Dad shows up knowing his rights, with the receipt stating exactly how much he paid and when. Attorney has nothing except a copy of the invoice for my dad's payment that he leaves in his folder the whole time. Not only does the attorney break almost every rule of court possible, he completely slanders my dad, calling him sketchy-looking and dishonest, even though the receipt is literally right there in front of him, and insists that the receipt is fake, despite having a copy of the invoice. It was real shitty stuff. My dad lost that case. Before anyone had even left the courtroom, the attorney walked up to chat with the judge, who asked if they were still on for brunch tomorrow. Because it was a super small circuit, this dude had been able to buddy up to a judge to the extent he was allowed to do basically whatever he wanted and still win his cases. A year later, my parents sued the attorney for misconduct and requested an out-of-circuit judge, who essentially told that slimy schmuck to sit the fuck down and shut the fuck up when he tried to pull something against the rules. They won that case. Story 5. Police routinely lie about dashcam footage to secure convictions. When I was working as a public defender in the Detroit State Court, I routinely saw cops lie about the existence of video recordings of an event. The law says they have to have the cams running when they make a stop, but in all the cases I saw, not a single cop was ever able to produce a video. Either the video had malfunctioned, been accidentally deleted after the event, or the camera was broken. It was a weird place to work. The cops very much viewed the defense lawyers and the legal process as their enemy. I'm sure there were a lot of unjust outcomes as a result. Story 6. Lawyer forces coma, patient to sign statement and sues for damages. A friend of a friend woke up in a hospital. He has no idea what happened, but he was brought out of an induced coma from a bike wreck. The car he ended up under was owned by a lawyer. The lawyer and a cop forced the doctors to get the guy out of a coma, long enough to sign a statement when no family was present. The lawyer never mentioned to the doctor that it was he who was driving, and not a person he represented. The lawyer then went on to sue for damages on his car by the guy and his bicycle. Story 7. Hiring private investigator to relapse son for inheritance challenge. Lawyer for 12 years here, specializing in estates and trusts. My client was challenging the will her husband left behind, giving the wife and son an equal split of the sizable inheritance he left behind. The son used to have an opiate addiction, but had been in treatment and a program, and had been clean for over 5 years. My client hired a private investigator who befriended the son and pushed him to start using again, selling him a few pills on hidden camera. The wife ended up using the video to successfully convince the judge her husband was under the impression their son was clean when he wrote the will, but since the video showed he still had a serious substance problem, the will could be challenged and he couldn't be trusted with his inheritance. She got the entire estate, and the son ended up dying a few years later from an overdose. Story 8. Opposing lawyer spreads false domestic violence accusations. Not a lawyer, but my dad sued his previous workplace for reasons. Long story short, the company's lawyer kept bringing up or suggesting he was guilty of domestic violence. He wasn't. At all. She just wanted to make him look bad. Now, if you Google his name, domestic violence comes up. I thought that would qualify as slander or something, but I guess not. I don't know how to make the little shrugging guy, and I'm not going to go find it. Story 9. Attorney wins cases while high on cocaine. Look around East Texas and Louisiana. We had an attorney who won quite a few of his cases high on cocaine. He died a few years ago from an overdose. Story 10. Faking intimacy and blackmailing prosecutor for lenient sentence. Not a lawyer, but I know of a pretty messed up case. It's kind of a two-parter. A lesbian woman I knew got married, and everyone thought the two women were happy. Turns out, the lesbian's wife was a con artist who was essentially gay for pay, until her real fiancé, who was on board with this whole plan, had been at his job long enough for benefits to kick in. His employer at the time did not provide benefits until after at least a year of employment. The real fiancé had been unemployed for a long time, hence the long con with the lesbian woman. She needed to suck the woman in, and then get married so that she could get on the lesbian's insurance, and also to convince her to pay for a phone. Literally, those were the only two reasons the female con artist was with the lesbian: health insurance and a cell phone. The lesbian and the female con artist get married at the beginning of summer. So the real fiancé gets his employee benefits about 7 months into the marriage of the female con artist and the lesbian. Meanwhile, this whole time, the female con artist is cheating, if you could really call it that, since she was never really loyal to the lesbian, on her wife with her real fiancé. So once the real fiancé gets his benefits, the female con artist tells the lesbian, "I was only with you for the insurance and a phone," and bounces. The female con artist files for divorce, and the lesbian is told by all law enforcement and every lawyer she consults that there is nothing she can do about basically getting conned because, 1, the con artist used her real name on all the documents, so the marriage wasn't fraudulent, and 2, you would have purchased those things for your spouse anyway, so you have no real damages to sue for. So basically the lesbian is heartbroken and completely screwed over. Since there were no kids, and the marriage lasted less than a year, the divorce was final in some ridiculously short time. Like a month. It may have been an annulment. Flash forward 2 months later, we get a call from the lesbian's mother. She's on the way to the hospital because she was just notified that the lesbian had been assaulted and was in the middle of getting a rape kit done. The story she told the cops was that she had been driving down the road and someone posing as a cop was following her, eventually pulled her over and assaulted her in the back seat of her own car on the side of some famously poorly lit road. Well, cops start investigating. The lesbian's whole story starts to unravel when they check the surveillance footage at a gas station that she would have had to pass by before turning onto the poorly lit road where the assault allegedly took place, only to discover that not only had nobody been following her, but she was the only car to drive in that direction for over 45 minutes. But her rape kit came up positive, How could this be, you ask? Cops did some digging and found a profile the lesbian had made on some dating site. They get a warrant and find out she made plans to hook up with some guy. They track him down, and he tells them everything he knows. He made plans to meet up with this woman, who turned out to be our lesbian. He met online, and as they are getting ready to have intimacy, and a few times during, she kept asking, "Have you ever had your DNA, deoxyribonucleic acid, taken? Ever had it tested? Are you sure you've never had your DNA tested?" Side note, that part is proof that no guy ever thinks clearly when he wants to get laid. Back to the story. So cops take a sample of the dating site guy's DNA to test against the DNA from the rape kit. It's a match. Cops figure out that the lesbian faked the assault by hooking up with this guy so there would be DNA. Said that the person impersonated a cop as a plausible reason why she would have pulled over where she did, and tried to say it happened somewhere that everyone knew there would be no direct evidence of her being there. The final question remained, why go through all that though? Cops confront the lesbian very carefully. They don't want it to seem like they don't believe her just because she's a lesbian, even though they have proof that she has been lying this whole time. When confronted, the lesbian admits everything: the dating site profile, setting up the dating site guy, lying, everything. Cops ask her why. She tells them about the female con artist, and somehow she reasoned with herself that if she suffered some sort of tragedy, like an assault, then the female con artist would come back and get back together with her. Like someone who conned you so intimately would really care, even if she really had been assaulted. She is initially arraigned very quickly, and in the intervening time it turns out that the cops tracked down the female con artist and got a statement from her. For some reason, the female con artist is in the courtroom when the lesbian is there getting arraigned. Now remember, the fake assault happened just 2 months after the divorce, or annulment, whichever it was. This arraignment was maybe a month after the initial assault report was filed, so figure 3 months since they last saw each other as a supposedly committed lesbian couple. The female con artist is 7.5 months pregnant. She got pregnant by her real fiancé at the beginning of fall, so she was able to hide it under heavy sweaters and such. So she was like 4.5 months pregnant when the original split with the lesbian happened. To this day, nobody knows why the female con artist was there during the arraignment. Okay, so the prosecution takes forever. For one reason or another, there were constant delays both by the lesbian's lawyer and the prosecutor's office where this was happening. They were going to throw everything they could at the lesbian because of all the money and manpower spent on the investigation. Plus, it had been somewhat high profile in that town. Charges included manufacturing evidence, filing a false police report, obstruction of justice, and a bunch of others that I have forgotten. She was looking at 5 years in prison, easily. Finally, the lesbian gets her lawyer to tell the prosecutor that if they don't let the lesbian plead down to some ridiculous misdemeanor, then at trial they were going to make it look like she was only being prosecuted because she is a lesbian. It was an election year, and the district attorney was terrified of not getting reelected, so they made the deal. She should have gotten at least 5 years in prison, but got off with a year of probation. I know this, especially this last paragraph, because the lesbian's mother, who was paying for the lawyer and should have been offended by her daughter's actions, because the mother was an actual assault victim, called my dad and regularly kept him up to date. She was proud of the fact that they basically blackmailed the prosecutor into a deal. If you don't believe me, direct message me, and I will give you a link to an article that was published on a news website about it. If you feel unsafe with your thoughts, please seek professional help. Story 11. Attorney lies about criminal record in traffic case. One afternoon, the attorney's assistant ran into my room and said, "I need to go to the courthouse right now to defend the attorney in a traffic case." The attorney told me he had no run-ins with law enforcement before, had never been ticketed before, and would just like to get supervision. I go in front of the judge and present this information, and I get him supervision. I go back to the office and curiosity got the best of me. I searched his criminal record. Yeah, turns out he had another outstanding speeding ticket, and you could see his mugshot for domestic violence. Story 12. Lawyer manipulates settlement document in divorce case. I didn't see it, but was told it. An attorney sent his opponent a draft settlement in a divorce case. His opponent changed vital clauses that favor his client, sent the signed document back without mentioning the changes, and the first attorney had his client sign it without noticing the changes. Story 13. Attorney doctors email chains to alter offers. My jurisdiction has an attorney who likes to change his opposing counsel's offers in their emails. For example, if the prosecutor makes an offer of 30 days incarceration, this attorney clicks reply and then scrolls down to the old email in the chain and changes it to 15 days, then writes a new email saying that his client accepts the offer. Sure, the prosecutor can check their original sent email, but if you just look at the email chain, it appears as if the prosecutor offered 15 days. This guy has never been sanctioned for doing this. He also likes to print out the doctored email chains and submit them to the court. Story 14. Lawyer and family exploit elderly client's estate. A lawyer who had an estate planning practice and shared an office with his dad, who was not a lawyer but did sell insurance and annuities, and who held himself out as a professional fiduciary, and with his mom, who had a business as a tax preparer. The lawyer also had a state job, and should not have had this side hustle. And a hustle it was. Long story short, his dad manipulated dependent adults and elders and got control of estates. In one case, they managed to make the shittiest imaginable investments and charge all kinds of fees for all kinds of stuff for a beneficiary who was HIV, human immunodeficiency virus, positive. Because of what they did, he ended up indigent, without money to pay for medications, got sick and died, and the so-called trustee and family ended up with a lot of fees in their pockets, and there was essentially nothing left in the estate. We nailed the parents at trial. They'd taken most of the money, but the son only took a minor hit, faced no discipline, and didn't lose his job. I think he later was either suspended or disbarred. Story 15. Defense attorney adds late expert witness before trial. We were getting close to trial in a medmal medical malpractice case. My partner eviscerates the sole defense expert at deposition. Discovery then closes. The following week, I have a pre-trial status hearing with the judge, and the defense attorney casually says they intend to add another expert on a wholly undisclosed theory of causation. I tell the judge discovery has closed, and after over a year of litigation, defense failed to designate any such expert, and will be moving to strike. The judge says we have time to depose the new expert before trial, and that's when I learned the scheduling order doesn't matter for the defense. Story 16. Lawyers and adjuster bilk carrier with fake mediation trip. I didn't see this but heard about it from multiple people. I'll credit the ID, insurance defense lawyer, since it was his plan, but plaintiff's counsel and the adjuster were co-conspirators. The three of them settled the case, but the defense lawyer and adjuster didn't tell the carrier. Instead, they told the carrier they were going to mediation, and it would probably last 2 days. The lawyers and the adjuster then spent 2 nights at a hotel, which happened to have a casino and golf course. They had to pay for their golf and gambling, but the carrier picked up the bill for the room, meals, and whatever hours the ID lawyer billed. Small price to pay for a successful mediation. Story 17. Attorney files lawsuit without client's knowledge. An attorney filed a property damage complaint, homeowner's insurance, spent a year or so evading our attempts to get verified answers to interrogatories, canceled and reset and canceled our deposition of his client, and eventually withdrew after I got a show cause order served on the client. The client herself actually showed up to the show cause hearing. She never knew that the attorney filed the lawsuit. Every excuse about how their client told them that she had an emergency or couldn't make the scheduled date, etc., was fabricated. She had never spoken with the attorney about the lawsuit. She had no idea. Story 18. Lawyer lobbies to kill bill benefiting homeowners. Billboard construction defect firm lobbying state legislators to kill a bill that would allow homebuilders and homeowners to bypass the firm and work together to fix. Story 19. Solo attorney faces unexpected client and new lawyer actions in ongoing litigation. A solo attorney with a 7-year relationship and 4 years of tumultuous litigation representation for a client under a large contingent arrangement has advanced about $25,000 in funds for 20 matters since 2021, including plenary actions, appeals, and motions, and dealt with a bar complaint from opposing counsel. This winter, the attorney negotiated a withdrawal or dismissal of an appeal bonded at $1 million, with a significant portion due to the attorney and the rest to the client, awaiting a signed order from the appellate court for the bond company to release funds. The client has been frustrated by the delay, but the attorney explained the limitations with the appellate court. Last week, without warning, the attorney received an email from a new lawyer, unknown to them, requesting a consent to change attorney, stating the client, through the new lawyer, negotiated a settlement accepted by the parties in the case where the original attorney is still counsel of record and has a charging lien. The new attorney also claimed fees and costs are disputed, to be held in their firm's escrow until resolved, and stated the settlement agreement with the defendant is confidential, leaving the original attorney in disbelief and questioning if the situation is just messed up or unethical. Story 20. New attorney may have committed barratry and tortious interference. Depending on the state, the new attorney may have committed barratry and could be liable for tortious interference with the original attorney's contingency contract. Story 21. Attorney manipulates elderly client for multiple fees in estate planning. An estate planning lawyer has an elderly client sign a will naming the lawyer as the personal representative or executor. There may be a question as to capacity, but he certainly used his influence to get his name in there. When she dies, he collects his usual fee for doing a probate, plus an additional fee for being the personal representative. Plus, he has a real estate license, so he hired himself as the listing agent for her house and made 3% of that sale in commission. It just doesn't seem right. Story 22. Opposing counsel lies about subpoena response in property dispute. Here's the one that still makes me angry. In a property dispute, one of the issues is whether my client sent plans and proposals to the municipal authorities for review and approval. Opposing counsel subpoenas the municipality and receives 1. An email from my client with an attachment sent for review and approval, and 2. The attached plans and proposals at issue. Awesome, third-party documentation shows the transmittal. We're done, right? Nope. The guy proceeds to depose the municipality guy who reviewed the plans. The guy says he doesn't recall if he saw the plans. We refresh with the email and plans, and the guy says, basically, I guess I saw it, I have no memory of it. Opposing counsel files a counterclaim for breach of fiduciary duty citing the deposition, claiming the guy said he never saw the plans. He proceeds to lie to the judge about the subpoena response and files a counter-affidavit on my motion denying that the subpoena response proves receipt, arguing it only shows transmittal, which, fine, assume that's true, it shows my guy met his duty. The judge blows it, fails to actually read the deposition or the documents, and doesn't believe my block quotes, I guess, because he denies my motion for summary judgment. We go to trial. I call the municipal attorney that answered the subpoena. He confirms that they had the email and plans in their email system and produced it. Call the municipality guy. He's now reviewed his emails to prepare for testifying and explains why he rejected the plans and proposals that he now definitely recalls receiving. The opposing counsel tries to impeach with, I don't remember testimony, and that goes nowhere. He later calls my client and tries to bully him into admitting he didn't send the email, and actually implies the city attorney and the client conspired to forge it. So, we win. Petition for fees. The opposing counsel screams that this was such a simple case, and there was no need to depose the municipality guy, or engage in all this wasteful litigation practice regarding his counterclaim. The judge rolls his eyes, cuts $30,000 from my fees for no reason, and denies my request for sanctions. This was the least enjoyable win, ever. Story 23. Boss misuses client funds through improper credit card deposits. One of my prior bosses had a credit card swipe machine in her office for clients to pay their evergreen retainer fee. No big deal on its face. Except the credit card machine directly deposited the amount into her business account, not her IOLTA, interest on lawyer trust account. The business account where she paid for her daughter's apartment, her dresses, her groceries, etc. Once I found out, it made me really sick to think of all the times she'd casually told our clients to just apply for a loan so they could keep paying her to work on their divorces. I reported her to the bar and left. Edited to be clear. She had been doing this since she opened her practice in the 80s. Her IOLTA had been opened and then nothing ever put in. In over 30 years of practice, no one had ever reported her until me. Story 24. Client attempts to avoid attorney fees by hiring new lawyer. I have a large contingent arrangement with a client I've known for 7 years and that I have represented in tumultuous litigation for 4 years. I have advanced about $25,000 in funds to handle 20 matters, plenary actions, appeals, and motions since 2021, and even had to deal with a bar complaint from opposing counsel at one point. This winter, I was able to negotiate a withdrawal or dismissal of an appeal bonded at $1 million, of which a hefty portion goes to me, a solo attorney, and the rest goes to the client. The appellate court has not yet dismissed the appeal. We are waiting for a signed order, so the bond company can release the funds to me. My client has been complaining that it's taking months for this order. I told him I am frustrated too, but it's the appellate court, and we have limited options. Last week, without warning, I received an email from a different lawyer telling me to sign a consent to change attorney, and that the client, through this new lawyer's legal services, has negotiated a settlement that was accepted by the parties on my case, where I am still currently attorney of record and have a charging lien. Not only that, but the new attorney I never heard of before states that the fees and costs are now disputed, and once the consent to change is signed, my claimed fees will be put in their firm's escrow until the dispute is resolved. And to top it all off, the new attorney claims the settlement agreement with the defendant is confidential. Again, I am the only attorney of record. I am in utter disbelief. 1. What the absolute crap? 2. Is this just messed up or is it unethical? Story 25. Client feels lawyer is working against them in car accident case. My daughter and I were in a car accident in 2015. Because I suffered permanent injuries, not serious but permanent, my family urged me to sue and I got an attorney. The attorney was referred to me by my workplace, but as it turned out, the attorney, a great person who communicated well, had to refer my case to another attorney because the opposing side would not negotiate a settlement and this attorney was not a trial lawyer. So the new attorney came recommended to me by my first attorney. The new attorney never introduced himself to me. He just took my case from the previous attorney and never said a word to me. I wasn't even informed if a suit was filed with the courts. I had to contact my previous attorney to find out that information. My current attorney had my case for 1 year before I ever spoke with him or met him, and that was when I had to do a deposition. While in that deposition, my attorney was on his phone the entire time. Fast forward about 6 months later and I get a call from my attorney's secretary who says the attorneys have reached an agreement. I said I have heard nothing about any kind of agreements. She said, well, they reached it and the papers have been signed. I said I want to speak to the attorney personally. Later that day, the attorney calls me and says, we reached an agreement. I asked, how much was the agreement? And they told me, personally, I found it insulting. And I said, I do not agree with this settlement, and I will not accept it. And I didn't like that he was making deals without consulting me first. So then fast forward 2 months and we go to mediation. In the mediation room just before we begin, my attorney asks the opposing counsel if they could chat privately, and they leave the room for a few minutes. When they both return, the mediator advises my attorney to start first. My attorney starts by saying he has waived his fees for this case and has advised his client, that's me, that the current offer on the table is the best offer I would get, stating there is just not enough evidence in the medical records to support anything past 1 year of treatment. He didn't even have all the medical records because he never asked for them. He just went with what the first attorney gave him and never went further into it. I personally don't believe my attorney ever read my medical records. My attorney did not fight for me at mediation at all, rather he cheered on the opposing counsel. Before opposing counsel began speaking, both attorneys went outside to speak alone again, leaving me in the room with both mediators again. They took a while, and so one mediator went outside to see what was going on, and then they still took a while before they came back. Finally, both attorneys and the mediator enter the room again, and my attorney comes in with cookies in hand, and it was the opposing counsel's turn to speak. While my attorney snacked on cookies, the opposing counsel said if I didn't agree to the current offer, then he would tear me apart in court by blaming other things in my medical history as to the cause of my current pain. He gave more details on that subject, but that is too much for this post. He even said that he would turn it around on me to be at fault for the accident, even though I was stopped at the red light. He said he would change it to where I unnecessarily slammed on my brakes, causing his client to hit me. And then my attorney says, "Do you understand what he is telling you?" And then he explains that he was in an accident in '89, and it was a rollover accident, and he still suffers neck pain from that occasionally, and said sometimes you just gotta get used to it. And he says this in front of the opposing counsel with a mouthful of cookies, and then says he just doesn't see where he has anything to fight for me in court. I replied, "I told your secretary, and I'm sure she informed you that I have a doctor appointment in 2 days. He interrupted and said, yes, she did inform him. In which, I'm requesting a letter from my doctor, which will confirm this injury is permanent. His reply was, well, it better be a really good letter. Then the mediator steps in and says, I think your attorney is trying to explain to you where he sees this case, and is trying to advise you to settle. I felt ambushed by my own attorney and the opposing counsel already, and now the mediator is getting in on the action. I felt bullied, and I felt like they were trying to intimidate me to settle. I did not settle. This mediation was only the third time I had ever spoken with my attorney in the 1.5 years he has had my case. It is also important to note that I have never signed any contracts or papers of any kind with him. It is also important to remember that the opposing side's offer has not changed since my first attorney had my case, and that was 2 years ago. So my current attorney did nothing to get a higher offer. My case is still open and we are headed to trial in July. But I feel my attorney is working against me, not for me. I feel like he has been in cahoots with the opposing counsel this entire time. How can I get out of this? Can I get a new attorney? Can I represent myself? What can I do? Please help. Story 26. New lawyer faces ethical dilemma over partner's discovery response. I work at a very small firm in civil litigation, so going upward isn't possible. I'm a pretty new lawyer. We assign cases to associates, such as me, who handles most matters, and the paralegals draft discovery, schedule depositions, etc. We got a post-deposition demand of a video or photos that paint our client in a bad light. The boss told the paralegal, in charge of responses, to answer that we don't have it. This has made me uncomfortable, for obvious reasons. Any advice on how to proceed ethically without jeopardizing my job? I'm in New York State if that matters. Thanks. Postscript. There have been some other things, but I couldn't overlook this. Edit. Can those with more experience or knowledge of ethics contextualize how unethical this is? For context, I believe the video would substantially diminish the value of the case. Story 27. Former associate fired for raising ethical concerns. Yeah, there are lawyers who conduct themselves ethically and those who will do whatever they think they'll get away with. I was fired while looking for another job for undisclosed reasons by my last firm, but there were just a rash of things that made me uncomfortable, in addition to me raising ethical concerns with partners because I'm silly and assumed it was a misunderstanding. I'm assuming this is why I was fired. The first yellow, in my opinion, red, but I guess that's debatable, flag was, I asked if a partner had considered calling opposing counsel, there were several related disputes, and it is a large publicly traded company who I previously represented the defendant in completely unrelated regulatory matters at a prior firm, and I told this partner that generally, the defendant and companies like the defendant were extremely reasonable on these types of disputes, and we could keep bills down for the client if we just gave opposing counsel a call to see if we could resolve at least a portion of the disputed funds. He laughed and said he was going to go ahead and file the lawsuit, no impending statute of limitations, and then consider calling them. Basically, he escalated a conflict that I genuinely think increased costs for the client without improving recovery. I chose to step back from the case, and I told the partner I didn't believe they had a legitimate claim. For your information, this case was in a niche area of law, for which I was brought to the firm, and at which said partner was not competent. I raised the issue that our litigation paralegal, yes, we had one to cover like 6 litigators, bullied all of the legal assistants to the point that they cried, and she tried to bully me over privilege designations. I insisted it was improper to claim privilege over documents that were solely confidential, personal identifying information, financial info, etc., not privileged. She was ultimately given a golden parachute because they found out she was having intimacy with 2 partners. Partners were also asked to leave. This included the partner from the prior anecdote, not because she was an jerk. They would also have legal assistants write motions for summary judgment and file them without review of a supervising attorney, and I fully believe this was billed out at a partner rate. The second one was not a violation of the code of ethics, but I believe it was among the bigger red flags, because if you refuse to fire someone for ongoing psychological abuse in your firm, your morals are already too screwed up for ethics to have any control over you. The third issue was the clearest ethical violation. The first was more of a hint at a style of practice I didn't want anything to do with, which I do think borders on unethical, though obviously a gray area, given it's based on discretion. When people tell you who they are, you have to believe them. Even if you asked about conduct wasn't technically unethical per the statutory rules. If something is a gray area and makes you uncomfortable, you need to seek out a different firm. Story 28. Opposing counsel fabricated evidence and communicated via backhand channels. I am currently in the middle of a legal dispute that has lasted 3 to 4 years. Opposing counsel completely invented evidence against me and somehow communicated this evidence to the court via backhand channels, such that I was not even aware of the accusation until the judge imposed sanctions on me. The evidence against this attorney for this ethics violation is 100% rock solid and inarguable. For example, let's say opposing counsel claimed I was in the library holding a rope on the evening of a harm and submitted a photoshopped picture with a timestamp 3 minutes prior to the harm. However, at the time of the harm, I was 3 states away, giving the play-by-play of the Super Bowl on national television. I only learned about the accusation when the judge issued his ruling 90 days later and imposed sanctions. This was a pre-trial issue, and at trial, the judge refused to reconsider, saying, quote, "We're not going to relitigate this." Prior to trial, after firing my negligent attorney and obtaining a qualified one, I was informed there was no legal mechanism to reverse the judge's ruling, and no opportunity for appeal. I am now considering filing an ethics complaint against opposing counsel. Story 29. Opposing counsel invented a cell phone provider for sanctions. We went to a temporary hearing over several issues, including my supposed refusal to turn over documents, specifically my cell phone records. On April 1st, opposing counsel submitted releases for my cell phone records, which I signed immediately and sent to my then attorney's paralegal, who sent them to opposing counsel. These included access to all my cell phone bills, and about a week before the May 1st hearing, we submitted a list of all my cell phone carriers to the court, which was accurate and complete. At the May 1st hearing, where only lawyers were allowed to speak, opposing counsel mentioned, "I told you last week about the fact that he had another cell phone account," but provided no further detail. On June 1st, during a break at the pre-trial conference, while my attorney was out, opposing counsel handed me a release for records from Bob's Cell Phone Emporium, a company I had never heard of and had no account with. I was told to just shut up and sign the release, and I did. knowing I had nothing to hide. On July 1st, the judge ruled on the May 1st hearing, sanctioning me to pay attorney's fees for refusing to sign a release from Bob's cell phone emporium, naming the company in his ruling. I am 100% certain I am not guilty, as I have never had an account with Bob's, and I can prove opposing counsel fabricated this accusation. At trial, opposing counsel alluded to this prior misconduct for further fees, but the judge shut down discussion, saying, quote, "We're not going to relitigate that," and my adversary was not awarded additional fees, as I won on most issues. There was no legal mechanism to appeal the sanctions, and I am now left to file an ethics complaint against opposing counsel.